decision under the, sorry, I just, right, I was just told the meeting's being live streamed, so good.
Yeah, so forgive me for interrupting, and for everyone that's involved in this, when I am holding hearings by Zoom and I'm not in an open courtroom where any member of the public can walk in and observe the proceedings, we live stream them onto YouTube so that people can observe them, so that the courts remain open and people have the opportunity to see what it is that we're doing. So now you're an influencer, Mr. Followell.
Oh, yeah, right. That's my big break. So, Your Honor, specifically, we're challenging a conclusion of law, and within Judge Malahi's final decision, there are findings of fact, and there's also a conclusion of law section. And the conclusion of law that Judge Malahi, the administrative law judge, makes is that at the time of the request for the state testing, the state administered test, pardon me, let me start that again. At the time of the request for state administered testing, the arresting officer informed the petitioner of his implied consent rights and the consequences of submitting or refusing. And that is a conclusion of law by Judge Malahi, and he checked the box indicating that that was one of his several conclusions. And that is that it references the statute that requires a DUI arrestee to be informed of his implied consent rights, and that is OCGA 40-5-67.1 subsection D, G2B.
Right, but Mr. Followell, as I read the petition, I don't think there's any dispute that the implied consent language that's required to be read was read. It's that there was some sort of discussion afterward that your client argues was misleading to him or confused him in some way about what his rights were. Is that accurate?
That is accurate. That is correct, Your Honor. And as the court knows, this appeal, this judicial review is governed by OCGA 50-13-19H, which provides the grounds by which this court may reverse or modify the final decision, where the administrative findings, inferences, conclusions, or decisions are in violation of constitutional or statutory provisions. And here we believe the error of law is the judge finding that the constitutional mandate of 40-5-67.1 G2B was complied with. And in regards to 50-13-19 subsection H, which governs which authorizes this court to reverse or modify the final decision, our appellate courts have said of that statute that the court is statutorily required to examine the soundness of the conclusions of law drawn from the findings of fact supported by any evidence, and is authorized to reverse or modify the agency decision upon a determination that the agency's application of the law to the facts is erroneous. And that comes from Pruitt Corporation v. Georgia Department of Community Health, and that's at 284 Georgia Superior Court 158. That specific quotation comes from page 161, and that's a 2008 Georgia Supreme Court case that does make the distinction between the very deferential any evidence standard for reviewing the ALJ's factual findings as compared to this court's duty when it comes to assessing whether there are any errors of law applied to those any evidence facts. Your Honor, the statute that I already referred to, 40-5-67.1b, provides that the implied consent notice, quote, should be read in its entirety, but need not be read exactly, so as long as the substance of the notice remains unchanged. And in considering whether an officer's implied consent note, in considering the reading of an officer's implied consent notice, the determinative issue is, quote, whether the given notice was substantially accurate so as to permit the driver to make an informed decision about whether to consent to testing. And that is found in a case that I believe Ms. John cites in our petition, Leiske, Leiske, versus State, 255 Georgia Appeals 615, and that's from 2004. While the cases cited in our petition for judicial review may reference criminal cases, that distinction makes no difference in the statutory duty that this court has under 50-13-19H to review whether the agency erred in its application of the law to the facts. Getting to the facts of the case, as Your Honor correctly noted, this is a question of not whether the implied consent was correctly read, but subsequent statements or a subsequent exchange between Mr. Moreau and the arresting trooper. Mr. Moreau, well, specifically, and it's, I believe in the record below, after the reading of the implied consent, Mr. Monroe asked, "What difference does it make?" And Trooper Cannell responded, "It doesn't. You're going to jail either way." Mr. Monroe did not ask, "What does it make a difference whether or not I'm going to jail?" He already knew he was going to jail. He'd been handcuffed and placed under formal arrest, as the law requires prior to the reading of the implied consent notice. While it may be true that Mr. Monroe was going to jail regardless of whether he consented or refused, the trooper's answer that it, quote, "it doesn't make a difference in regards to whether he submits or refuses testing," was confusing, misleading, and defeated the purpose of the implied consent notice by stating that there were no consequences to consenting to or refusing. It was confusing because the possibility, if not likelihood, that it would mislead Mr. Rowe into believing that his answer would have no effect in any respect. Indeed, Mr. Monroe immediately followed Trooper Cannell's statement by refusing chemical testing of his blood, and as a result, Mr. Monroe's license was suspended. The case law, which is cited in our petition, is clear that misleading or confusing information does not have to be intentional, nor does a correct reading of the implied consent notice make any confusing or misleading statements surrounding implied consent irrelevant. We cite—
Right, but to Ms. Correa's point, though, aren't most of those cases in the context of whether or not statements made consent, indicating or refusing consent in that context can be used against them in criminal prosecutions? And isn't that a difference that matters here?
Well, no, I think that the statements in question in several of the cases that we cite in our petition actually are relevant to this context because it defeats the statutory requirement that the substance of the implied consent notice, even though it doesn't have to be read exactly, it must be accurately conveyed. The substance needs to remain unchanged. And these cases like State v. Terry, Wallace v. State, Kitchens v. State, even though those deal with whether test results or whether the refusal of consent to testing is admissible. And those same concept, the same principles apply here. We are talking about the suspension of a person's license, and the statutory mandate is that the substance, even if the implied consent notice is not read verbatim, that its substance remain unchanged. And here, the substance was changed by the subsequent exchange between Mr. Monroe and Trooper Cannell. And based on that, we believe it was an error of law to conclude that the statutory mandate that implied consent notice be read and its substance remain unchanged. We believe it's an error of law to conclude that was complied with. The State v. Terry.
Forgive me for interrupting, Mr.
No.
Fellow, but I think one of the things that I'm struggling with in the context of this case is that I understand the difference between a finding of law and a finding of fact, and that being a significant difference because you apply different standards to it in this context. But how is the judge's determination that this conversation did not negate the import of the implied consent having been read? How is that not a finding of fact rather than a conclusion of law?
Well, Your Honor, I don't know if it's an express finding of fact as far as that it was accurately read. I believe the conclusion of law that, I think it is a conclusion of law that whether it was communicated correctly without any substance being changed, and it's denominated as such in the final decision. So we do believe that is a legal conclusion in this matter. And is made as such. And as you can see, if the court saw the original final decision, that is part of their form, that is one of the conclusions of the law that the judge has the option of making by checking the box. Your Honor, not to belabor the point, but certainly the cases that we've cited, State v. Terry 236, Georgia Appeals 248, a 1990 case, 1999 case, where the court excluded refusal to testing based on inaccurate information, and that is because the driver was misled into believing that he had to post bond first. Wallace v. State 325, Georgia Appeals 1, page 142, it's 2013. That is a case involving the correct reading, but the driver was provided with subsequently misleading information. And the Georgia Court of Appeals notes in the Wallace case that it makes no difference whether the officer's misleading statements were unintentional. The determinative issue was whether the misleading statements changed the substance of the implied consent notice. Kitchens v. State 258, Georgia Appeals 411 from 2002, reversed the trial court's, the Court of Appeals reversed the trial court's admission of state testing, where the per se legal limit was misstated, and the court said it could not conclude this misstatement did not influence the decision to consent to testing. Your Honor, in conclusion, I'll say in this matter, we have Trooper Cannell making a misleading and confusing answer to Mr. Monroe's question. It cannot be said to be harmless. I mean, which is of course why we're here, because it resulted in the suspension of the license. The trooper stated that Mr. Monroe's decision made no difference since he was going to jail, whether he consented or refused testing. And then Mr. Monroe immediately responded by refusing the trooper's request for testing, resulted in the suspension of his license. And we believe the administrative law judge erred in his conclusion of law that the officer, quote, the officer informed the petitioner of his implied consent rights and the consequences of submitting or refusing to submit such tests. Based on this error in law and pursuant to this court's statutory authority, we ask that you reverse the decision below issued by the Office of State Administrative Hearings.
Okay, thank you. Mr. Followell, before I hear from Ms. Correa, one quick question.
Yes.
On your request to submit additional briefing. When do you believe that you could have that briefing filed so that the court would have access to it?
Your Honor, I can have it filed by for this particular case, for the end of this week, if that satisfies the court.
Yep, that's fine with me.
Okay, thank you.
So that would be 3, is that 4-1? Yeah, okay. Ms. Correa, am I pronouncing your name correctly?
You are, Your Honor.
Thank you.
Thank you. Your Honor, as Mr. Followell has stated, the standard for facts finding of the ALJ decision is clearly erroneous, and as long as there is any evidence to support it, the court should affirm. The order of the ALJ as one of the factual findings, number 6, states that after being advised of his or her implied consent rights, the petitioner refused to submit to the state administered designated test designated by the arresting officer. That is a factual finding by the court. The subsequent legal conclusion is that the petitioner in fact refused. But with respect to whether or not he was advised by the officer, properly advised by the officer, and refused, was a factual finding made by the court, and that is should be reviewed under a clearly erroneous standard. The cases cited by the petitioner are all criminal cases in the context of those statements then being used in a criminal case. There are no cases finding that stating that the officer's statement that the driver was going to be arrested anyway, which was accurate statement. It was not misinformation. That was an accurate statement. There are no cases that suggest that adding that statement to the implied consent notice invalidates that notice for purposes of a suspension. In fact, the cases regarding suspensions clearly show that anything except an acceptance is a refusal. I mean, you have cases where the driver just won't respond, or the driver just fails to consent but doesn't actually say the word no. Even those, in the context of a license suspension, are sufficient for the suspension. And those cases are Miles versus State 236, Georgia Appeals 632, and Adams versus State 270, Georgia Appeals 878. Here, the trooper explained what he meant when he said it doesn't make a difference. He said you will be arrested anyway. He did not say anything about the context of the suspension. And that even in the context of criminal cases where there is no misinformation, the consent notice is not suppressed. And those are, State versus Frederick, cited in our brief, and Satterfield versus State, also cited in our brief. So we would ask that the license, that the court affirm the ALJ's decision. I would add that I believe we filed our brief back in November, shortly after the petition was filed. If the petitioner is going to file a brief, I would like an opportunity to at least respond.
So, and that's what I suspected would happen, because we lawyers don't do well with being told that we don't get to have the last word. And so here's what I will say. So Mr. Followell has indicated that he can provide a brief to the court March the 31st. I can tell you that I'm not going to be addressing your brief the following week because I'm going to be on spring break with my kids. So if you wish to file a reply, which, by the way, my standing order requires that you ask permission to file a reply brief, I'm going to dispense with that necessity. But if you wish to file a reply, just let my staff know that you intend to file a reply, and it needs to be done in very short order, because of course a reply is intended to specifically respond to new things that have been asserted, rather than just another chance, as we lawyers always want, to say the same thing again. So, I don't think that a week is unreasonable. If Mr. Followell files his additional brief by the 31st, which is Friday, that next week, if you want to let us know that you'll file a brief and that you intend to do so by whatever that following Friday is, the 7th of April.
I will, yeah.
And then the court will take into account whatever briefing it has at that point, and we'll issue a ruling. Okay.
Appreciate it. Thank you.
Thank you, Ms. Correa. Thank you, Mr. Followell.
Thank you, Your Honor.
Okay. I am going to skip over a couple of cases because I've got sort of the same issues, and it makes sense to sort of address them all at the same time with everyone's permission. And so I'm going to move on to case number 2023 CV 376130, which is Mackenzie Vargas versus Spencer Moore. Ms. Taylor, that's position 6 on the calendar.
Thank you, Judge.
Ms. Johns, are you ready to proceed on that one?
I am, Your Honor. Thank you.
Thank you. Ms. Correa, are you ready to proceed?
I am, Your Honor.
Okay, excellent. Ms. Taylor, are you ready?
Yes, Judge.
Okay, excellent. This is going to be a hearing in the matter of Mackenzie Vargas versus Spencer Moore. Case number 2023 CV 376130. Ms. Johns, if you would like to go ahead.
Thank you, Judge. My name is Amanda Johns and represent the petitioner in this case, Ms. Mackenzie Vargas. I'm here with the City of Atlanta Public Defender's Office. And at the outset, before we get too far into it, I would ask for the same consideration in terms of filing a brief. I can have one by the end of the week, no issue. And if the court would extend that.
Yeah, absolutely. Fully expected you would request it and fully expected to agree to it as well.
Thank you.
Same rules that any additional briefing you wish to submit will be by Friday, March the 31st. And if Ms. Correa, on behalf of the Department of Driver Services Commissioner, wishes to respond, she will do so no later than, let me look at my calendar again, just to make sure I have the date right, April the 7th.
Thank you.
Thank you.
Thank you, Judge. And to move forward, we're of course here today on behalf of Ms. Vargas, asking this court to reverse the suspension below. I won't go through, I think at least from the last case, I think the court's aware that we're here under 50-13-19 and the scope of, but I do think that in Ms. Vargas's case, there is a threshold question regarding the scope of the hearing below.
Well, and let me ask you this, Ms. Johns. So this one was one that was a more bare bones pleading. And so even looking at the record, right, I was very confused because as I understand the approach, it's that the court erred. We'll discuss whether it's a factual error or a legal error, but that the court erred in finding that she had engaged it, that she was initially stopped for some sort of traffic violation. But I don't have any insight or factual information about why that would be challengeable. And I will say, in fairness, Ms. Johns, to how you might structure or frame your response, in that context, it seems to me to beg the question that means the court was making a factual determination based on testimony and evidence that was presented to them at the time, the Department of Driver Services. Anyway,
yes,
go ahead.
Yes, Your Honor. So, and I am ready to argue the factual argument here, but and I apologize. I'm rather new to these APA appeals, and I didn't realize. I apologize that I didn't have something between the petition and the argument that was a little more clear where we're going. But at least what I can say is that the argument today is in two parts, and it's based on the argument that it was an error based on the facts available on the record. It was plain error for the judge below to make the determination that Ms. Vargas committed a traffic violation. And really the argument that we're presenting today, especially after reading the response from Ms. Carrera, it looks like it's really a two-piece argument. And it sounds like the first question, the threshold question that this court would have to answer, is whether the court below was required to determine that there was actually a lawful arrest that took place. And if that answer is in the affirmative, then what the question is, was the arrest actually lawful? And
Ms. Johns, forgive me for interrupting you, but let me, with my newfound information about the administrative process of suspension of a license secondary to the criminal prosecution for the alleged DUI, wouldn't necessarily the determination that a lawful stop occurred resulting in a DUI already have been adjudicated in the criminal case?
No, Your Honor, I don't think the criminal,
It's okay.
right, the criminal case hasn't occurred yet. So we're prior to that case.
Okay.
Right. And under 40-5-67.1, that's the code that governs the scope of the hearing below. Subsection G21 is a subsection that's particularly relevant here because we are focused on whether that initial stop was supported by any cause. So if this court determines that that is part of the inquiry below, then we can move forward. If not, then I think we're stuck there, but I'm prepared to argue it all today, Your Honor. But with regards to subsection G21, it clearly dictates that within the scope of the hearing, the ALJ must determine whether the law enforcement officer had reasonable grounds to believe that the person was driving or in actual physical control of a moving motor vehicle while under the influence of alcohol or on a controlled substance, and was lawfully placed under arrest for violating code section 40-6-391. I think for two reasons, this court can feel comfortable that the scope of the hearing below is designed to question whether the arrest below was lawful. The first being, it's literally the language of the statute that governs the hearing below, calls into question whether the arrest was lawful. And if the officer in Ms. Vargas's case had not even reasonable articulable suspicion, so he could pull her over if he had probable cause, he could pull her over if there was reasonable articulable suspicion that criminal activity was afoot. And as Ms. Carrera points out, if there's some exception or justification to avoiding reasonable articulable suspicion, then he may have a reason, or he may have cause to pull her over. That may survive the challenge that we're mounting today. But because the scope of the hearing questions whether there's a lawful arrest, the ALJ is required to determine whether that initial investigatory detention or probable cause, custodial arrest, whatever you want to call it at that point, was supported by legal cause. And we are arguing that it was not. Even if the fact that we're in the context of the issue before the court today is really a constitutional issue. So we're not in the criminal context. We're not invoking the exclusionary rule. We're not arguing that the stop was pretextual. We're arguing that the client, Ms. Vargas, I think case law has clearly established that there is at least a property or liberty interest, however the court wants to describe it. There's a significant enough interest that she has in her privilege to drive in the state of Georgia, that there is some process that must be in place to protect it before a deprivation of that interest occurs. And so Georgia has settled on this statutory procedure that's outlined here at 40-5-67.1 for implied consent to respond to the issues that are the due process issues that may be present. And even if it wasn't clear in the statute that one of the questions that the court below has to determine is whether or not an unconstitutional seizure is resulted in the deprivation of her interest at this stage, it would be implied that it has to happen anyway, because that's the whole reason the state is required to have this process in place. And Georgia's made it really easy in that it outlines in that particular subsection that within the scope of the hearing, the court below has to determine that there was a lawful arrest. So
And what's the standard for that?
I'm sorry.
So by a preponderance of the evidence?
I believe below the standard is preponderance, Your Honor.
Okay.
Yes. Right. So I'm not arguing that it's a very high standard at any point in my argument, because if we're able to move past that threshold inquiry, whether the court below must inquire as to whether or not the arrest itself was a lawful arrest, then we're in the realm of what was the encounter that took place between the officer and Ms. Vargas in the first place, right? So the record clearly demonstrates that the officer believed that he had probable cause to pull her over for a violation of Georgia's offense of changing lanes without using a turn signal. And so the testimony on the record is that the officer says that on or about, I think it was October 15th in 2021, he observed her around 1:30 in the morning, if I'm not wrong, in a silver Nissan pulling up to an intersection, and that she changed lanes without utilizing her turn signal. So he pulls her over. The facts on the record demonstrate that there was no oncoming traffic headed in her direction, and that the only vehicle behind her was the officer's cruiser. The only facts in the record about where the officer's cruiser was is that the officer testified himself that it was a good bit of distance behind her, and that there was nothing in between him and her. I don't remember exactly how that shakes out, but there were no vehicles behind her except for his vehicle, and he was a good bit of distance away. And then the officer further explains that in response to her changing lanes, he had to take no evasive action to avoid her car. Case law in Georgia has clarified that in this code section, and I believe it's 40-6-123B that she's charged with, that the code section does not require that a turn signal is always used when someone is changing lanes, but only when required. And the cases have established that it could be because oncoming traffic needs to know that you're about to turn, traffic behind you needs to know that you're about to turn, or some iteration of that. But in this case, the facts demonstrate that the only relevant car would have been the trooper's cruiser. And I think that respondent points out in her response that there is case law, and if I'm not wrong, it's the Muhammad case is one of them, wherein the trooper's car or the officer's car was the subject car that triggered that requirement that the driver use the turn signal. But in every single one of those cases, the car was immediately behind the driver. In this case, the record below, the facts below are very clear that the trooper was a good bit of distance behind her. And there are no facts on this record on which the ALJ could have determined that there was a vehicle somewhere that could have been the vehicle that triggered the requirement that she use her turn signal. So that the officer does not have probable cause to pull her over in this situation for that offense.
So, Ms. Johns, let me ask you this though, because one of the things that concerns me, and that was to my question at the very beginning, is that, I mean, I understand that the way the law is structured, this is set up on a parallel, separate administrative track from the criminal prosecution of the alleged DUI.
Yes.
But it also concerns me that you're asking me to revisit what I think is clearly a factual determination about whether the officer was justified in pulling her over or not at the administrative level before that evidence is tested in the context of a criminal prosecution. And so I'm a little concerned about that posture, number one, and number two, curious if there is any case law or precedent that would give me guidance on that issue.
Yes, Your Honor. So to answer your question or your concern in two parts, the first is I am asking the court to inquire into the facts that are on the record. And I'm actually arguing in this case that there is no evidence on the record to support a factual finding that the officer had probable cause that 46-123 subsection B occurred. And in terms of the second piece of this court's concern, that sounds like it sounds like perhaps the court's leaning into, am I about to create an issue of collateral estoppel? Like, how can I decide this at this point and not jeopardize the criminal prosecution?
Right. Which is one of the reasons I asked you about the applicable standard, because obviously in a criminal prosecution, it would be a little bit significantly different, but.
Right. And the cases are not going to roll off my tongue, but I actually was just reading one last night in anticipation of this today. I wish I'd written it down, but and Ms. Carrera, I'm sure what Ms. Carrera, I'm sure likely to disagree, but what I'm familiar with are cases that require, I think there's several different factors in order for collateral estoppel to apply. And the most relevant ones I would suggest right now, but I can pull some cases as part of the brief that I'm going to file, is whether or not it's the same parties or people or individuals who have privity to the parties, and whether or not the individual or the parties were given a fair opportunity to fully litigate the issue below. And I've not yet seen a case where collateral estoppel applied to preclude evidence being introduced at the criminal trial because it was dealt with in the context of the administrative hearing. And it's usually on that second issue because the state is not usually at liberty to just appeal a finding below. So we are in a bit of a different position because petitioner has filed this appeal, but I think the reasoning still stands because I do believe that the opposing counsel is going to be limited to arguing this petition. So I'm not aware of any case that has found that collateral estoppel or res judicata was an issue enough to prevent the full judicial review of the issues below. And indeed, I would argue that the review process is set up so that under 5013-19, in particular, particularly relevant to the argument I'm making, which does have a constitutional dimension to the property interest here, that not only is the court required to, or not only is the court looking at any evidence standard on the record, But if the record demonstrates that there are no facts to support even an investigatory detention, then we have a constitutional issue. And there are several subsections of 15, 13, 19, which would apply, starting with it. The suspension is in violation of constitutional or statutory provisions of the agency because it is the result of an unlawful detention. And also just that where there is an unconstitutional seizure of a person that then results in a deprivation of the property interest that Georgia has recognized people have in their privilege to drive, and there's no stopgap on that, then we're up under subsection 6 of that code, where it's an arbitrary or capricious deprivation that's occurring. So I will definitely pull some cases for the court in my brief to address the collateral estoppel issue. But turning back to the stop, not the estoppel, but the stop, we would argue that there was no probable cause for the stop, and that the case law interpreting that code section over and over again, it makes it clear that when required language means that there are situations that where it's not required. And I believe that not just the facts, but the totality of the record in this case demonstrates that not only were there no facts to suggest that the turn signal was required, but that indeed there's nothing to suggest that it could have been required. The next question would be whether the officer had reasonable articulable suspicion, because there are cases wherein someone gets pulled over, for example, for a failure to maintain lane, but at trial, they're eventually acquitted of that charge because the finding is that the person was really just weaving in their lane and never actually failed to maintain lane. And the court determines on the motion to suppress, for example, that it's irrelevant that the initial traffic offense didn't occur because the officer had some articulable suspicion that something was going on. This case doesn't have that at all. There is nothing to suggest that there was any reasonable articulable suspicion of anything happening, much less reasonable articulable suspicion that she was required to use a turn signal and didn't use a turn signal, but there's nothing else. So if the court is with me that far, then the next question that the court should have is whether, and I believe opposing counsel cites to the good faith exception to the exclusionary rule, whether there's some exception like that or some justification for the seizure that took place when Ms. Vargas was pulled over that would somehow get around the obstacle of this is an unconstitutional seizure if you don't even have reasonable articulable suspension, and it's clearly not a consensual encounter because she had to be pulled over. And at the outset, I'll note that I would disagree that the good faith exception applies in this context because we're not dealing with the exclusionary rule. But I do think that it is helpful, the cases that sort of establish the good faith exception are helpful to understanding why, in this case, it wouldn't matter if it did. And it doesn't make sense that there's any other sort of justification that gets around the issue of cause for the actual detention, because it's starting with the Hine, and I'm not sure if I'm going to pronounce this right, but the Hine case from North Carolina that established that, an officer's good faith mistake, good faith belief that something was going on, even if it later turned out to be incorrect, a good faith mistake, a good faith mistake, in fact, may justify the fact that there was no reasonable articulable suspicion. And then in Georgia, I think the Court of Appeals has the Abercrombie case, which takes Hine and analyzes it for Georgia's purposes. And in all of those cases, I mean, the question that should guide the court, whether or not the court believes there's a good faith exception here or not, is what was the mistake that the officer made? Are we dealing with a mistake of law? Are we dealing with a mistake of facts? And in this case, we're arguing this would be a mistake of law because the officer felt like, or he believed that just the fact that she changed lanes required the use of a signal, and that is legally incorrect. And then the second question that should guide this court in that analysis is if it is a mistake of law, was it an objectively reasonable mistake of law? And Kagan's concurrence in the Hine case makes that a really easy question to answer. And I'm gonna misquote it just because of my anxiety here today, but it's essentially, is it plain on the face? Is it really easy to understand? Is it ambiguous in any way? And Georgia case law has already answered that for this court. There's nothing ambiguous about 40-6-123B. The turn signal is only required at certain points. The facts in this case demonstrate, I mean, the plain facts on the record demonstrate that not only do none of the circumstances exist that would require the use of a turn signal, but based on everything that the officer testified to, there's not the possibility that something could have been there to justify the requirement that she use a turn signal. So even if we get past probable cause and we get past reasonable articulable suspicion, even if the court is questioning whether there's some exception or justification that gets around the requirement, there is no objectively reasonable mistake of law here based on Georgia case law interpreting this code section. So that even with that, I think this court is required to reverse the decision below, because otherwise we're dealing with an unconstitutional state action that results in the deprivation of petitioner's interest in her license. And that question, that constitutional question, is one of the questions that the hearing below is required to address. And we know that because the judge below is required to find that the arrest was lawful. And in this situation, there is really no way to make that a lawful arrest. And so on that, I would ask you to reverse, and thank you.
Thank you, Ms. Johns. Ms. Correa?
Thank you, Your Honor. Well, like the court, we were a little bit at a loss as to what the issues were in this case, other than, obviously listening to the record below in the hearing. But because the petition, I don't think mentions due process at all or any other argument. But I will say that the statutory language governing the scope of the hearing below is that the ALJ was required to find whether the law enforcement officer had reasonable grounds to believe the person was driving or in physical control of a moving vehicle while under the influence of alcohol or a controlled substance and was lawfully placed under arrest for violating 40-6-391. We read that statute to mean that the issue is whether the law enforcement officer had reasonable grounds to believe both that the person was driving under the influence of alcohol and then was lawfully arrested.
Right, but to Ms. John's point, right, I think as I understand Ms. John's point, had he not stopped her, right, then he would not have a basis to have any of those beliefs, right? Because the assertion is that she had watery eyes, that sort of thing, upon interacting with her personally. And as I understand it, the only allegation of improper operation of her vehicle, such that the officer said, this is why I pulled her over, and upon pulling her over, this is what I observed, is this changing lanes issue, which, full disclosure, I mean, it's written in the imperative. It says shall. So I'm a little surprised to hear the characterization that you're not necessarily required to comply with it, or that a law enforcement officer would know necessarily that you're not required to comply with a rule that says you shall use your indicator such, so that cars coming towards you or approaching from behind would be able to see what your intended change is about to be. But go ahead, Ms. Correa.
Well, the testimony below from the officer was that she suddenly changed lanes. She was in the left lane. She suddenly changed lanes. He was following behind. She didn't use a turn signal. And the ALJ accepted that testimony and found that she was stopped for a traffic violation. From there, I don't think there's any dispute that that the officer had, after stopping her, had probable cause to arrest for the DUI. And I haven't heard any argument about that at all. There are some cases in Georgia about, and they're not consistent. I mean, all of the cases that I found where the driver, including a police car, was behind the driver that failed to make a turn signal, the courts found that that was a violation of the statute. There are some where, where the courts, Georgia courts have found that that a signal was not required, but 2 of those are not binding precedent, because out of the 3-judge panel, only 1 judge, concurred in the actual opinion. So I may have missed it, but I did not hear Ms. Johns. I actually cite some cases. But both Clark versus Georgia and Bowers versus Georgia are not binding precedent on this court. The only other case where I found was Georgia versus Jones, and that was the case where the police car was parked and there were no other cars around at all. There, the court found that the signal would not have been required because there were no moving vehicles on the road. Here, the officer testified he was behind her. He did say he was a good bit of distance behind her, and he didn't have to maneuver around. But that doesn't, that does not necessarily mean that she was not required, in our view, to use the turn signal. And the ALJ found that she was stopped for a traffic violation. And even in the context, if the officer was incorrect about the applicability of the statute requiring a turn signal, and he clearly believed that she was required to use a turn signal. There was no testimony below suggesting that he was using it as a pretext or anything else. He clearly believed that. But the Georgia courts and cases cited in our brief, both McBride versus State and State versus Mohammed, have said that, if the officer makes a mistake, that does not mean that the initial stop was in violation of the Fourth Amendment. There is no, with respect to due process, there's no. I mean, I will wait to see the petitioner's brief on that and appreciate the opportunity to respond to it. But the only due process right in the state constitution would mean that you have a right to a hearing, which the state statute clearly provides, and you can raise at that administrative hearing, while the court cannot decide it, constitutional matters, which the petitioner does, and then appeal it to this court. So that satisfies the due process clause. And this statute, 40-5-67.1, governing the scope of DUI hearings for administrative suspensions, has been upheld by the Georgia Supreme Court. I don't have the case off the top of my head because I wasn't expecting this as part of the argument, but I will certainly get it to the court. And I do not have anything else, Your Honor. That's all I have on this matter.
Thank you both. So Ms. Johns, we will end where we started, which is that I do intend to look for any briefing that you wish to submit by March the 31st. And then Ms. Correa will have an opportunity to file any reply that she chooses on behalf of the commissioner by April the 7th. And then once I have those materials and return from spring break with my kids, then I will review those briefs and get you a ruling as quickly as I can. Thank you all for your time. I do appreciate it. Ms. Johns and Mr. Followell, I think that probably concludes your matter. Ms. Correa, I think you've got one more matter to take up. And actually what I'm going to do is take about a 3-minute break to go get some more coffee and let my court reporter rest her fingers. It's 10:33, so by my clock anyway. So if we can resume at 10:40, we'll go ahead and get started. Thank you all. Okay. Before let me go ahead and finish up the driver services cases. So the next one will be Mr. Basin.
Yep, I'm here.
And Ms. Correa.
Yes, John.
Thank you. So I do not have a note that or takedown was requested on this matter. So Ms. Taylor, rest your fingers for a few minutes.
Okay, thank you, Judge.
Okay, so this is going to be a hearing in the matter of Vadim Basin versus the Georgia Department of Driver Services case number 2022 CV 372236. Mr. Basin, I have received your materials and reviewed the pleading the materials that you filed, and just to sort of get us where we need to be, here's my understanding of the relevant factual situation, and then you can correct anything that needs to be corrected or, take it from there. My understanding is that you were pulled over for a speeding ticket, and that the nature of that speeding ticket was such that it also implicated a super speeder ticket, that
Correct.
You paid the direct ticket to whatever municipal or county government issued that ticket. And then subsequently, the state sent out a notice, which I believe I understand you dispute having ever received. The state sent out a notice indicating that in addition to the fine, you owed a super speeder of $200, which you challenge. I think because you did not receive it, but I'm a little less clear if you substantively are challenging it as well in terms of the authority of the state to impose it, or if it's just an issue of notice.
It is an issue of notice. Sorry. Go
Okay.
ahead.
And so that's what I understand to currently be the situation. So Mr. Basin, if you want to take it from there, sir.
Yeah, all the facts you mentioned are correct. And I did. So here, I'll start at the beginning. I'm going to say that the notice of charges against an individual are fundamentally essential for the individual to be aware of them, right? And any subsequent actions that the individual must take to remediate them. Lack of such notices cause significant harm to the individual being charged by taking away their ability to act on these charges, whether the individual would have chosen to appeal them or take proper actions to remediate them. And this harm is aggregated with every day of such notice not being provided as the individual continues about their day, unknowing that certain privileges, such as driving privileges, have been or will be revoked, or additional fines will be assigned as a result of an action.
So Mr. Basin, forgive me. Let me save you a little bit of trouble.
Yeah.
Completely agree with you that notice is fundamental. It's a matter of due process. In order to have due process, you must be given notice and an opportunity to be heard. So that's not really in dispute. I think the issue that I'm going to hear from the state is, what is the nature of their notice obligation? And so if you want to direct your comments to that issue, because so the address that would have been on, say, a driver's license, that would have been part of the ticketing issue is where the state is required to direct its notice. And one of the issues that I'll need to resolve or just be educated about from either you and or Ms. Correa is, oftentimes notice is sufficient, not always, but sufficient if the party providing notice can demonstrate that it was mailed or sent and directed to an address known to be correct. They don't actually often have to prove that it physically got into your hands. And so if you could direct your comments to that issue, it would be very helpful for the court.
Okay. Yeah. So, I can cut to the chase here. So when I appealed to Georgia Department of Driver Services, I received and I pointed out the fact that this notice was never provided. I received a final decision from a hearing officer saying that, that the charges will remain against me, and that I owe, whatever fines are associated with it. But that final decision never disproved the fact that or didn't try to even present any evidence that they mailed out this notice. And so I do see that here in the evidence that is now being provided, that there is, and I'm not even sure if this is admissible in an appeals, in an appeal process to provide this kind of new evidence, that there is a printed, apparently, version of this notice Still, I don't think it, it doesn't necessarily mean it was ever mailed or whatnot. But the original point is that there is significant issue with this notice not being provided, me driving, not knowing that I'm apparently being charged of being a super speeder and have a certain timeline to meet to until my license is revoked and whatnot. But then upon, finding out with a second notice, I go ahead and appeal to the, Georgia Department of Driver Services, and they never even disprove it in that process. And that is what this appeal here is about, and that they never even disproved in the appeal process to, DDS that any notice was not provided.
Okay, so the record that was presented it contains an official notice dated May the 17th of 2022 and mailed to an address in Illinois, addressed to an address in Illinois. And so I guess part of what I want to understand your concern or complaint is, so as I understand this is the evidence that the Department of Driver Services presented indicating that they provided you with notice. And so your position is that there's no evidence that they actually mailed it?
Well, initially, when I appealed to DDS, they did not present this evidence, right? So their judgment was based on, it didn't even mention what I actually, essentially accused them of, which is not providing notice. So their initial ruling was based on any kind of lack of evidence from their side that they even tried to mail it. And I have that in my petition, an example, or the exhibit that shows their final decision. It mentions nothing about the notice, not being or being sent to me when that was what I actually appealed to them about. So you do see now, or they're showing now that they did print, I guess, notice. And again, I'm not sure if this is, allowable to present this kind of like new evidence, but initially in the process that that DDS has, they were able to come to this conclusion of the final decision without presenting any evidence. And I think that's the initial problem here that I had. And I still never, so that's why, I appealed here, is because I never saw this evidence presented. I knew for a fact that I never received it. So as far as I knew, up until DDS recently submitted these documents, that they essentially agreed that they never even sent this notice, and that caused, significant harm in me losing, my driving privileges later on, being charged extra fines and just driving around not knowing that, I was being charged as a super speeder. And I'll note that also in the DDS's file that they submitted, answers and defenses, on the 4th page, they even in point 6, they kind of trail off and trying to reply to my claim that they never try to disprove or provide any evidence against, when I told them that in my appeal to DDS that they never sent me any kind of notice. So they say, in response to paragraph 6 of the petition, respondent admits only that on September 29, 2022, and then that just ends. And point 6 in my appeal or in my petition was that they never provided any counter evidence that they actually mailed out the notice. So in their own process, they made a final decision based on no evidence. And so that essentially is the largest problem here. And that's why I never thought this evidence would even come to light, because I was pretty sure that they were aware that they never mailed this notice or even generated it. It seems like now they did generate it, but no real proof of mailing it here.
Okay, thank you, Mr. Basin. Ms. Correa, can you address this issue of notice and what is the obligation? Is it, for example, I have another case on my calendar today where the statute very clearly requires proof of delivery or non-deliverability to the address. And so tell me, what is the obligation of the Department of Driver Services when delivering this type of notice? Is it the mailing of it? Or is there, what is the standard here?
The statutory language just obligates the department to notify the driver of the imposition of the fee. And there is no clear law either way, Your Honor, to be clear.
Well, I mean, there's
But
tons of law about what's sufficient notice. And so
yes, but
absent, and that's why I was asking is, absent a specific provision that says in order to accomplish notice, you must do X, Y, Z, which there are in some other statutes. That's sort of what I was asking you.
there is not in this particular statute, but the primary issue here is that the imposition of the super speeder fee, the $200 fee, comes from once the petitioner pled guilty to the speeding ticket of driving 90 miles an hour in a 70 mile an hour zone. So it's not that, DDS has no, was under a statutory obligation to impose the fee. It's not as though the lack of notice can negate the fee. I mean, it could give the petitioner another 100 or 90 days, I'm sorry, to pay the fine, but the petitioner doesn't dispute that he received notice of the suspension in September and he still has not paid the super speeder fee. So that I don't think DDS nor the court has discretion under the statute about whether or not the $200 fee, super speeder fee, is applied in this case. The only discretion may be with respect to the additional $50 fee for reinstatement, given the petitioner's argument that he never received the initial notice. And so that's all that lack of notice would trigger, is perhaps an additional time to submit the $200 fee before his license is suspended. Or it's not license in this case, it's because he doesn't have a Georgia license. It's just the privilege to drive in the state of Georgia.
Well, but by extension, he's licensed in Illinois, right? So this had the effect of causing a suspension of his license in Illinois.
I don't know Illinois law, but yeah, it very well could, yes. And, DDS does not oppose giving him, striking the $50 fee, but the $200 fee imposed by the super speeder statute is not discretionary. I mean, DDS just has no discretion on whether or not to impose that. It is tied to the conviction back in 2022 for the speeding ticket for driving 90 miles an hour on a 70 mile an hour zone.
Well,
So once that conviction came through, DDS had no alternative but to impose the fine. I will say also that this petition was filed against DDS, which is not a proper party.
I understand. It's technically supposed to be against Mr. Moore, the commissioner.
Right. So we would argue that the petition be, dismissed for that reason as well. But with respect to the super speeder fee, even if, the agency record which was filed shows that it was mailed. But even if it had not been mailed, that would not negate the imposition of the super speeder fee in this case. There just is no discretion in the statute. And there's nothing in the statute that provides that the lack of notice means that the super speeder fee shall not be imposed.
If I may add here.
Hang on.
Oh, sorry.
That's okay. You may respond briefly, but before you do, I wanted to make sure that Ms. Correa was done with her presentation.
I am, Your Honor.
Okay, thank you. Mr. Basin?
My request initially to waive the $200 super speeder fee was just something that I found was applicable for the situation, given that this in my opinion erroneous action of not having mailed this notice, which I don't believe still this record shows that it's essentially been mailed, caused in essence if I was caught with another infraction, not having known that I was had a super speeder charge, would have caused more, irreparable harm to my driving record, or had suddenly my license been revoked while I was driving the state of Georgia, and it was suddenly suspended at the time when it was, that would have been even further consequential in that I, would have been stopped with driving with suspended license. So this lack of notice is, the $200 waiving the $200 fee, I thought was just a kind of, relevant way to provide relief for this situation. But I don't know the correct amount of relief that would be required for this scenario. I just provided that, the $200 waiver would be just relevant to the harm that was caused by this lack of notice, which I still hold was a lack of notice. And again, on this record, I'm not sure where on this record it says it was mailed or whatnot, but in the initial, ruling by the hearing officer of DDS, they did not even present any evidence of this initially. So I'm not even sure, I'm not sure if this is evidence is even admissible in this scenario.
Well, the materials that were provided to me are materials that would have been considered by the hearing officer at the time that the decision was issued. And that's the record that's been provided to me by the agency. And it's the same record, just for your information, Mr. Basin, that was provided to me in the last two cases that you've sat through here, obviously arguing about different issues, but same process, that the hearing officer is provided with certain information that's in the record. And that's what's provided to me at the time that I am to consider the issue. And at the end of the day, the reason that I challenged you, Mr. Basin, about the issue of notice is that generally speaking, the existence, while it may seem, it may be frustratingly simple, in terms of that it's not some big affidavit or certification, et cetera. Generally speaking, the existence of the presentation to the hearing officer and to me as part of the administrative record of two notices that were mailed to an address that seems to be associated with you, or was at least associated with the ticket that you received, would constitute sufficient notice. And I'm not, as Ms. Correa pointed out, I'm not aware of anything that would require any other action by the state. But more importantly, it seems as if you now do have notice of the super speeder. And what it really boils down to is the legal substantive obligation or the legal substantive exposure to that super speeder fine has already been decided because you pleaded guilty to the underlying offense by paying that ticket. And so I don't believe that the court has any authority to waive or dispense with the super speeder fee. And even to the extent that I'm sympathetic to you about having to pay a fine, an additional $50 reinstatement fee because you didn't pay the fee in advance, I'm not aware of any procedure that would authorize me to do that either. Now, Ms. Correa may be in a position, since the two of y'all are now in direct communication, to authorize some sort of negotiated agreement between the parties that if you pay the fine, the super speeder fine, that your license would be reinstated without that $50 reinstatement fee. But that's a conversation for the two of you to have, because the legal issue before me is whether or not the super speeder fee may lawfully be imposed upon you. That's what I understand the judicial review, the action that is being reviewed. The hearing officer below determined that the super speeder could be legally imposed upon you. And on the record before me, there's no reason to question that judgment. And so, Mr. Basin, for that reason, I am going to uphold the decision of the hearing officer or affirm the decision of the hearing officer, and then suggest to you that you and Ms. Correa discuss how you might go about getting your license reinstated after payment of that super speeder fee or after exercising any appellate rights that you choose to exercise. Ms. Correa, can you please provide me with a proposed order very briefly outlining what I've just ruled?
Yes, Your Honor.
Okay, thank you. Ms. Correa and Mr. Basin, thank you for your time and your patience this morning while I dealt with other matters, and you both may be excused.
Thank you for your time, Your Honor.
Thank you. Okay, before I take up the next matter, I did want to revisit the matter of Fudos Inc. versus Kenneth Poole. I know I have Mr. Poole here. He announced his presence earlier. Do I have
Yes, ma'am.
anyone? Right, thank you, Mr. Poole. Do I have anyone here on behalf of Fudos Inc.?
Judge, I called Colum and Brandt Law Firm, where Mr. Brandt is the attorney listed on this, Charles Brandt. He was sent this notice back on, I believe, the 14th. To the correct, I confirmed that was the correct email address in e-file, Georgia. It showed that he had not opened it. I spoke to his, their legal assistant. She said he was in court today. I emailed.
He could have educated us about any conflict he had he opened the notice and been aware of his obligation to appear.
Right.
It's 11 o'clock here. Calendar started at 9:30. It's going to be dismissed.
Okay.
Mr. Poole?
Yes, ma'am.
Just so you're aware, this is a peremptory hearing. So the notice that was sent out to Fudos Inc. and their counsel and you indicated that failure to appear could result in dismissal. And no one has appeared on behalf of Fudos Inc. after an hour and a half. And so that matter will be dismissed. Do you understand, Mr. Poole?
Yes, ma'am.
Okay, you may be excused, sir.
All right. Thank you so much.
Thank you. Okay, I'm going to take a quick break real quick before we take up what I believe is that last matter, and I will be right back with all of Okay. Mr. Whitley?
Yes, Your Honor.
Hey, just wanted to let you know that oh, I can't remember who it was, but someone appeared, Mr. Caskey, that's who it was, and indicated that they had received the city's approval about 10 minutes before the hearing, and y'all had already sent me a consent order. You were just waiting on the city's consent. So I've got what I need, and my understanding is it's a consent order, so you are free to be excused.
Okay, again, I just wanted to apologize. I had it calendared for 10 a.m., not 9:30, so just wanted to pop in and apologize. And
No worries. It happens to the best of us. But generally speaking, if you ever look at a calendar and it says 10 o'clock for me, always question that because my hearings almost always start at 9:30. So.
okay, I will do so. Thank you, Your Honor.
No worries. Thank you, Mr. Whitley.
All right.
Okay. So I think that leaves the last matter that we have, which is the Amanda Reeves versus Jonathan Burt case. I'm sorry, Amanda Reeve versus Jonathan Burt. So before we get started, I do want to, so there are a couple of things that we need to take up. One is, here's what I understand from the announcements is that Mr. McNally and Mr. Nail, is that right?
Yes, Your Honor, like
Okay.
a hammer and a nail.
Okay, excellent. That they intend that they have a motion to dismiss that they wish the court to hear. Typically, the court would hear a motion to dismiss before hearing substantive evidence. In truth, I was reviewing this matter last night and I don't recall seeing a written motion to dismiss, but it may just not have been accepted by the clerk yet.
There is not a written motion, Your Honor.
Okay. Well, in that case, then let me move on to the second part of what I was going to address. So one concern I have is when I first received this and was looking at it, I was very confused, Ms. Reeve. And in truth, the reason that I was confused is because this is not something that is typically presented to a Superior Court judge to review. And so when I received it and was confused because it was not something I typically see, I immediately attempted to do some research to figure out what is the appropriate legal posture. And hang on, I just was looking at my court reporter and realized that you guys had requested takedown of this matter. So I should probably back up and start over so we have a complete record. Ms. Taylor, are you ready?
Yes, Judge.
Okay. And the parties are ready?
Yes, Your Honor.
Excellent. Okay, so this is going to be a hearing in the matter of Amanda Reeve, R-E-E-V-E, versus Jonathan Burt, and that's B-U-R-T, case number 2023 CV 375876. I'll note for the record that Ms. Reeve is proceeding pro se, and that Mr. Burt is represented here by Matthew McNally and Garrett Nail. So as we began, one of the things I wanted to know to sort of just explain to everyone is what I understand to be where we are in the case and some concerns that I have before we get into any substance. And that is, number one, the announcement that I got from Mr. Burt's counsel was that there was a motion to dismiss, which I've noted there is not a written one in the record. But that led me to a larger issue concern. And it's because, as I started to say a moment ago, this is not an issue that I've ever seen before. And so because I had not seen one before, I wanted to do some research to determine procedurally how it was presented to me, what would be the applicable appellate review standard for me, what would be the evidentiary standards for me to apply. And here's what here's the best information that I've been able to develop. So I am not aware of the denial of a warrant, which, as I understand it, Ms. Reeve applied for a warrant. I understand there's some other procedural background related to a TPO, but that what's squarely before me is that Ms. Reeve applied for an arrest warrant regarding an alleged strangulation, I think an attempted murder by Mr. Burt, that took place sometime in 2020, and that Judge Frazier of our magistrate court denied that warrant. And my review of the law of Georgia does not provide for a specific direct appeal of such an action to the Superior Court. Now, giving Ms. Reeve the benefit of the doubt as a pro se litigant, it probably could be properly characterized, and I think procedurally is best characterized as a writ of mandamus, right? A petition for a writ of mandamus seeking to compel Judge Frazier to grant the warrant that was requested. And the reason that that matters to me, besides the fact that, of course, we want to make sure that we're right and applying the right law, but also because it controls the scope and extent of this hearing, because a writ of mandamus is based on an alleged abuse of discretion. And whether or not Judge Frazier abused his discretion in denying the warrant that was presented to him necessarily requires me to limit my consideration to the evidence that was presented to Judge Frazier at the time, rather than hearing new evidence. And so I would like to invite the parties very briefly, without getting into the substance, to address that issue as I've presented it, and tell me what your questions, concerns are on that topic, because I do believe that it controls how we will conduct ourselves in this hearing this morning. Ms. Reeve?
Yes, Your Honor.
At the time that you presented the warrant to Judge Frazier, did you present evidence to Judge Frazier? Did you make argument? Did you provide him with information?
I provided him with information. I also had an expert medical witness who was a part of the, she's part of a network of people who know a lot and have been trained on non-fatal strangulation. She cannot be here today. We tried to get her, but we only had 7 days notice, a business day's notice. And unfortunately, she tried as best she could to change her calendar and figure it out, but she couldn't. But I do have her testimony in a form of, a deposition.
Okay.
To present to you. But the main thing is that, and to get to the point, because I know your time is very valuable, the main thing is that Mr. Burt's lawyer said during that court case, he said, is it possible that Ms. Reeve could have had injury to her neck from holding on to a banister post? And Ms. Steinbrecher, who is an SA.
Oh, Ms. Reeve, forgive me, because I will hear from you about the substance, right? But right now, I'm really asking you to direct, and that's why I asked you about what evidence you presented to Judge Frazier, because legally, as I understand it, my review should be limited to what was presented to Judge Frazier and whether, upon considering that information, he abused his discretion in declining to grant the warrant that you requested.
Photographs were not presented to Judge Frazier. And
I'm sorry, say that again?
Photographs were not presented to Judge Frazier, and witnesses who I have on the line right now were not allowed to speak.
Okay. Okay. Thank you, Ms. Reeve. Mr. McNally or Mr. Nail, response, questions
Sure.
associated with what I've just laid out?
Judge, this is Garrett Nail on behalf of Mr. Burt. We think the court's right to question its jurisdiction or procedurally where we're at. And that was the substance of our intended motion to dismiss. We had a little bit short notice. Mr. McNally and I couldn't pull it together in written form fast enough to get it before Your Honor. But effectively, our position is just what the court's saying, which is court needs to take a look at how this matter came before it. Mandamus may be one way, Judge. We were actually focused on certiorari. And there is a statute 543. I have it pulled up. I don't know if screen sharing would be of any help.
I don't think it would. I'm very familiar with the certiorari requirement.
Right.
And I will say that, well, no, go ahead. Go ahead, Mr. Nail.
Sure, Your Honor. So we did a bunch of research because, like Your Honor said, we were unfamiliar with the appellate procedures as it related to a denied warrant application.
As was I.
Right. And I couldn't find any case specifically on point. I'm more of a civil lawyer. Mr. McNally is more the criminal lawyer. We sort of put our heads together to try to figure this out. And what we came up with is that the proper approach is the certiorari process, Judge. Our view of that statute is that anytime a litigant is complaining about the decision of an inferior court, that litigant has the right to seek certiorari. It's not a civil matter, which has its own code section. And a magistrate court is an inferior court. I found a case that says that. And so the proper process was to go through the certiorari protocol, which requires, Your Honor said you're familiar with it, you have to have the application filed. It has to be sanctioned by the appropriate judge. The application has to specifically set out the alleged error so that Your Honor or somebody sitting in your shoes can take a review of it and
Mr.
decide.
Nail, forgive me for interrupting you, but I am very, very
Okay.
familiar with the process that's required to satisfy and get a writ of certiorari issued. I'm also very familiar with the procedural process that would need to be followed, slightly less onerous than a writ of certiorari to do a writ of mandamus. Also aware that the legislature has decided that that is such an onerous burden that they've abandoned it entirely. And beginning in, I think, July of this year, we will no longer have most of those things. And so, right or wrong, the fact that she is a pro se litigant, I think, in fairness, the court should consider how it got here. But I don't necessarily think that it serves the purposes of what we're here for, to get trapped up in whether or not Ms. Reeves satisfied the certiorari obligations. Because I'm less sure that they apply, because most of the case law that I saw, particularly in the context of issuing a warrant, I was trying to look at my email to find it over the week that I looked at over the weekend, seemed to indicate that a writ of mandamus requiring the judge to issue the warrant that was requested would be the appropriate procedural response. But either way, I agree with you that there are procedural requirements that are necessary that I would expect a lawyer to have satisfied before presenting either a writ of certiorari or a writ of mandamus.
Right, Judge. And I won't spend any more time going through the procedure itself. What we do know, though, is the transcript hasn't been filed. The errors haven't been enumerated. And to your Honor's original point of sort of what are you reviewing and what is the scope of your review, we don't believe that has been properly presented. On mandamus, Judge, I will defer to Mr. McNally, who might have more experience with that. I candidly have dealt lots with certiorari, not so much with mandamus. And so unless Mr. McNally is ready to address that issue, we'd obviously like a chance to get into it more. But we agree with the court that its review needs to be limited. And going forward today, if the case is not dismissed, which is what we would ask, then we've got to take another look at what exactly are we doing before Your Honor.
Okay, and the basis for the dismissal, to be clear, is that there are minimum procedural requirements that Ms. Reeve, rather than a direct appeal process, that Ms. Reeve did not satisfy, whether it's a mandamus or a certiorari petition. Is that roughly correct, Mr. Nail?
Correct. And from the case law I've reviewed, I understand that's effectively jurisdictional and not waivable. And Your Honor, or anybody sitting in Your Honor's shoes, does not have the authority to expand the time requirements of that procedure. And so our position is it wasn't done properly, it's time barred, and the matter now needs to conclude.
Okay, thank you, Mr. Nail. Ms. Reeve, I know that you are pro se, but whether it's a civil case or a criminal case, I'm technically not supposed to treat you any differently, right, than I would a lawyer. But I did want to give you an opportunity if you had questions about what we were just discussing, or if there were points you wanted to make on that topic in terms of how you got here from Judge Frazier's denial of your warrant application. You're muted, Ms. Reeve.
I'm so sorry. I didn't mean to.
That's okay.
I apologize. No, I don't really have any questions. I can only say that the reason why I am pro se is that I've called over 28 lawyers in 3 years. And everyone said, why are you calling me? The DA's office needs to be in charge of this. And I've spoken to the DA's office, and they actually spoke to me last week. But I have to be pro se because the only people that I've had that I can hire are criminal defense attorneys. And the best criminal defense attorney that I was able to speak with said, why are you calling me? You're a victim. I can't defend you because my work is defending criminals, not victims.
Okay. So the reason that all of everything I said at the beginning, and then add to that what Mr. McNally and Mr. Nail, or I guess Mr. Nail has added, is if there is no procedure for a direct appeal of a magistrate judge's decision in this context, right? Because clearly a magistrate judge's order on many matters is directly appealable to the Superior Court. If there is no procedure for that, which I don't believe that there is, that rather the appropriate procedure is either seeking a writ of mandamus or a writ of certiorari. As Mr. Nail has pointed out, those things, and I commented on as well, those things are very complicated procedurally. And there is a question, Ms. Reeve, as to whether or not, if those procedures are not followed, as to whether or not the court has jurisdiction to enter any order substantively on the issues before it. I'm going to take that matter under advisement. And I'm going to move a little bit into the substance, but I do want to be clear to everyone involved that the part that I am clear about, whether, assuming that I have jurisdiction to hear the case, to decide the issue, the standard that would be applied would be an abuse of discretion standard, and that standard necessarily is limited to the information that was before Judge Frazier at the time. And so one issue I have is typically there is lots of case law that says if there is not a transcript or a clear order so that I might review the materials or matters that were presented to Judge Frazier, that it would be difficult, if not impossible, for the court to exercise any review because I don't know what was presented to Judge Frazier. Ms. Reeve, you raised your hand, you had a question.
Yeah, Your Honor, I just wanted to say I've requested a transcript to be taken down for that proceeding, and it was not responded to.
I'm not exactly sure how that would work. Usually, if you want a matter taken down in magistrate court, you have to provide a court reporter, or if you request it and it's not something that's able to be provided, then at the point when the hearing begins, you understand that you're proceeding without a court reporter.
Okay.
And the risk of proceeding without a court reporter is that you then don't have the ability to create a record, particularly here where all Judge Frazier did was enter an order denying the warrant. Mr. McNally?
Your Honor, the fact that there's not a transcript would then create more work essentially for Ms. Reeve to attempt to recreate a transcript.
Well, certainly there is a procedure by which a party can testify through affidavit or otherwise as to what was presented to the court.
It would create yet another problem for the review, Your Honor. And I don't know if there is enough to do anything substantive today, Your Honor, as far as the record is how it's before us, Judge.
I tend to agree with you. I think my bigger concern is assuming that I have jurisdiction, I guess my question is, can it be remedied such that could a continuance, right, a reset to another day, allow Ms. Reeve to marshal her resources and attempt to provide the court with some documentation as to the matters that were presented to the court?
Respectfully, I don't have anything that I can share with you regarding the last court date. I don't have any way to document it. I've requested documentation. It was not granted. So if I could go back in time and do it, I would. But I've requested it many times. I could provide the emails where I've requested documentation for a takedown for that particular court date that was not responded to nor granted.
Okay, thank you, Ms. Reeve. Mr. McNally?
Back to your honors inquiry about if you were to give a continuance. I think there's case law that might bar her or your honor from extending some timelines. For certiorari, I would have to research that because there are some very specific timelines in the certiorari statute, your honor. But that would be something we would litigate. I mean, if your honor did decide to keep the timelines open, that would be something we would want to litigate, Judge. I think in the mandamus, if it's, it's either certiorari or mandamus, I think maybe in the mandamus, it might be a little clearer, the timelines, but certiorari is it's crazy is what it is.
Which is why the legislature said,
right. Yeah.
Let's get rid of that.
Yeah. So I would have to research that. But it would definitely be something we would want to litigate. So mandamus, I don't think you can extend the timelines. Certiorari possibly, but I would have to do some more research on that.
Okay. Ms. Reeve? Oh, I'm sorry, Mr. McNally.
I'm done, Your Honor. Thank you.
Ms. Reeve, did you have anything to add, ma'am?
I don't necessarily, but I will say this is that this is definitely a complex situation. I have very strong evidence against the respondent, which has been weirdly not absorbed by the powers that be. I've had to go off on my own, and I never wanted to do that. I've always tried to seek counsel. But the thing is that this incident happened in the height of COVID, when everyone was on lockdown. And it was the same week that the George Floyd riots were happening. There was a lot of stress on the police department. I actually am the new head of safety for my entire neighborhood because everyone decided that it made sense because I care so much about not having anybody else have this happen to them. I am the head of safety for my neighborhood. I have met with the head of the police department. She told me that they did not follow the right protocol because they did not have the right training. And all I can say is that's what I know and that's what I can tell you. And I wish, I'm in this nebulous area where I was not married to, I did not have a child with, and I did not live with Jonathan Burt, even though we basically slept in the same bed every night. So it is an issue of intimate partner violence, but that back then was labeled differently. And that was 3 years ago. And that's all I have to say. I don't know what you can tell me to do. Just if you can help me, that would be great.
Okay. Thank you, Ms. Reeve. So,
Judge, I don't know if you want a slight response to that, just a little procedural history for your honor. So the incident happened on May 20th, 2020. Police officers responded to the scene. Officer took down a statement at the night it happened. It was referred to investigators. They interviewed Ms. Reeves. They interviewed Mr. Burt. I took Mr. Burt over to the officers. They interviewed. Officers decided not to issue a warrant. There's a TPO hearing that was set and heard by Judge Manning on December of 2020. We had a 2-day hearing on it, Judge, 2 days.
That
tons
is
of,
actually incorrect.
Excuse me, Ms. Reeve. So the way this works is one side talks, then the other side talks. So you will, if you want to make notes, I'll give you a chance to respond, but let Mr. McNally speak. Go ahead.
if it wasn't 2 days, it felt like it. There was a lot of testimony brought in to the TPO hearing. Judge Manning heard it, denied it. 2 years later, in May 19th of 2022, almost at the 2-year anniversary, the criminal arrest warrant was filed, application was filed. We had another hearing, same exact allegations, same time, same place, same interaction, another hearing on it. Judge Frazier denied the criminal warrant application. So in essence, this, I mean, Ms. Reeve has, got review from officers. It's been reviewed by Judge Manning in a civil context, and it's also been reviewed by Judge Frazier in a criminal context. And I think it's safe to say that there have been enough judicial eyes on this case, all coming to the same conclusion.
Thank you, Mr. McNally. Ms. Reeve, I promised that I would let you respond.
Thank you. I'm sorry. I didn't mean to speak out of turn. I apologize. What I would like to say is that I did not have appropriate counsel, and I've been told that I should have not even needed counsel. And if I could present to you, which I know we can't do today, it sounds like we're not going to do it. I have ample evidence from my emergency room records and expert people looking at my emergency room records, and people who saw me the day I was attempted, like I almost died. Like, that's why I'm still doing this, is because is hearsay allowed in this court or no?
Well, generally hearsay is not allowed for lots of different reasons. But for today, it's not that it's not allowed because it's hearsay. It's that the court is not really considering factual matters right now.
Okay.
So I would prefer that you refrain from injecting those types of factual issues for right now.
Okay, well, because I have people that have told me this person has hurt them too. So, I don't know what else to say. Honestly, Mr. McNally is going to say the things he needs to say to represent his person. You can look at the guy in the background. He's smiling. Like, I have lots of video evidence where he's laughing and joking and thinking that everything that happened was just funny. And it's not. It's a serious matter. And I have every person I have found on the planet who's looked at my medical records and said, yeah, this happened to you. So I don't know what else to do.
Thank you, Ms. Reeve. So let me say a few things. So I'm very sorry, Ms. Reeve, that you find yourself in this circumstance. I can only imagine the frustration that you must feel in an effort to pursue this, or to have someone pursue for you the allegations of this awful incident that occurred back in 2020. Here is my problem. You've already heard me sort of outline what my concerns are about the procedural posture of the case, but one of the reasons that I think substantively underscores why it is incumbent upon me to refrain from acting in this situation is that one of the reasons that there is not a direct appeal issue associated with a warrant is that we want to not only not encourage, but discourage judge shopping for warrants, right? And that doesn't matter if it's you as an individual person seeking an arrest warrant, or if it's the police, right? We don't want a police officer or an individual to go to Judge Frazier, get a not answer that they want, and then say, oh, well, I'll just go to Judge Krause and she'll give me a different answer. And that's why procedurally it's so important that the court only consider the information that was presented to Judge Frazier, number one. Number two, beyond that is the issue that even to the extent that the court were to consider, let's say for a moment, the court were to assume it has jurisdiction, right? Which I think is an open question because the mandamus and certiorari provision or procedures were not followed here. But let's say the court were to sort of jump over that and say, Ms. Reeve is pro se, the court is willing to at least consider some of the substance. The second issue that arises from that is this issue that there is no transcript. There is only the ruling by Judge Frazier. And so the court wouldn't have the ability to consider what was presented to Judge Frazier. And while I understand, Ms. Reeve, that might also be very frustrating to you, the court can only, the court is limited to legal decisions in this context rather than having a full presentation of new evidence, because again, that would encourage judge shopping. And so for all of those reasons, as frustrating as it must be to you, Ms. Reeve, and again, I'm very sorry. It pains me to tell you that there's not anything that I can do for you, and even more so that I don't believe it would be proper for me to hear the evidence that you were prepared to present today. But I don't believe that the matter has been procedurally postured correctly before the court. And so I do think it would be subject to dismissal. But even if it wasn't subject to dismissal, even if I were to assume that I had jurisdiction under either a mandamus or certiorari model, I don't believe substantively there's anything for me to review because I don't have a record of what Judge Frazier considered and what he heard at the time. And so for those reasons, to the extent that I've been asked to revisit that warrant, the denial of the warrant, my decision would be that the appeal itself should be dismissed. And in the absence, even if the court were to consider it in the absence of a record, that the decision of the court is not able to review the decision of Judge Frazier because it doesn't have any knowledge of what information Judge Frazier considered to know whether he abused his discretion, which I believe is the appropriate procedural standard when he declined to grant the warrant. The only other thing I can tell you, Ms. Reeve, and again, I wish I had a better answer for you because, you know, I don't control the district attorney's office, right? And so the district attorney has prosecutorial discretion to determine what cases it will pursue and what cases it will not pursue. And I don't have any more authority over them than you do. And so I'm sorry that there's not more that I could do to address your concerns. But procedurally, this is the appropriate resolution here. And the court will enter an order to that effect, and then the parties can proceed in the manner that they believe is appropriate in terms of an appeal or revisiting the underlying warrant or following up with the DA's office. Any questions, Ms. Reeve?
No, thank you, Your Honor. I think you've told me everything I need to hear.
Okay. Anything, Mr. McNally or Mr. Nail?
No, thank you, Judge, for your time today.
Thank
No,
you
Your
all
Honor.
for your time. Thank you, Mr. McNally. Thank you all. Have a good day.